G'day everyone, and welcome to the 12th and final week of materials in Laws 3006 Administrative Law. By this point, you pretty much know all of the administrative law I'm going to teach you. But this is not a theoretical subject. Administrative law is all about real people who have real problems and who need help. If you go away from this subject thinking that mandamus is a cool sounding word, but with very few ideas about how to use administrative law to help those struggling against poor government decision making, well then I've completely failed in my mission this term. So in this last week, we have two videos. The first one looks at some controversies in administrative law, real life issues, and real life questions about how we resolve them. The second video I hope you'll find super useful. In that video, I'm going to walk you through a flowchart which will help you tackle pretty much any administrative law problem, at least at a basic level. So let's get started. The first controversial issue I want to raise is the issue of remedies. Think back a few weeks to when we were talking about the remedies that are available in administrative law. The courts and the tribunals can set decisions aside. They can remit them back to the department. They can stop things happening. They can force people to do their duty. The tribunal can amend a decision or even substitute its own. They can make declarations. Did you notice, though, that the fundamental remedy, the basic remedy that we see right through the common law, is not available? I'm talking here about damages. Should the government be liable for damages if they make a poor administrative decision? Imagine two people who arrive at an airport to get on an overseas flight. The first person gets to the check-in counter, but the staff member there, who's employed by the airline, makes a mistake on the computer. And she says, "I have no record of your ticket." The staff member won't issue a boarding pass. The passenger can't fly. That passenger has an action in contract law, because they've paid their money but the airline has made a mistake and hasn't kept its side of the bargain. The traveller gets damages. The second person gets their boarding pass all right, but then when they get to the passport point, they get pulled out of the queue and interrogated and denied access to their flight. And it all turns out to be a big mistake on the part of one of the customs officials. The second person is in basically the same position as the first one, but the second person can't obtain damages. If the private industry makes a mistake, you can sue for damages, but if the government does, you can't. Is that fair? The government does have a scheme called the Scheme for Compensation Caused by Defective Administration, but it's discretionary. The government gets to decide whether you're entitled to anything at all and how much. If the government, through defective administration, causes you harm, why shouldn't the court be able to impose damages in order to compensate you? Personally, I think this would be a crackingly good reform. I think nothing would raise the standard of public administration quite as much as knowing that if decisions are made badly, the department may well have to pay compensation. What are your thoughts? The second controversial issue I want to raise relates to a thing called outsourcing. Outsourcing occurs when a government department, instead of doing things in-house, makes a contract with some external agencies to provide those services instead. From a legal services perspective, this might happen if a department moved from having its own in-house legal team to engaging an external law firm and simply paying them for their services. More generally, there's a massive company called Serco, based in the United Kingdom but very active in Australia, which does everything from running immigration detention centres to running government bus lines to providing guards at military bases to providing laundry services for hospitals. Instead of the government providing these services the way that it once did, the government merely pays money and the outsourcing company does the actual stuff. What does this mean for administrative law? Well, sometimes it may mean that decisions are being made or actions are being taken which are fundamentally administrative in nature, but they're not being taken by a government organisation. And the private organisation may be immune from administrative law. This means that by outsourcing a function, the government might not just be outsourcing the work, They could also be sneakily avoiding scrutiny. So should non-government organisations, which are in effect making administrative decisions, should they be subject to administrative law? In a British case called DataFin against the Panel on Takeovers and Mergers, the UK moved towards a principle where a private organisation exercising public power could be subject to administrative law. In Australia, in a case called Neat Domestic Trading and the AWB, the High Court flirted with the idea of implementing the DataFin principle in Australia, but didn't quite get there. What do you think? Should the DataFin principle be incorporated into Australian law? Again, from my perspective, I really think this is a change that needs to be made. From the perspective of the average citizen, if they're going to the government to make an application or seek a decision, it's completely beside the point whether the decision is made within the department or outsourced to some other organisation. They should have the same rights of review regardless. The final controversy I want to discuss looks at what happens when a decision is made by multiple government agencies. It's not uncommon for decisions to be made which actually involve a bunch of agencies making different lower level decisions, which then contribute to the overall final decision. To take a relatively simple example, a request to alter the dimensions of a road intersection might involve decisions or recommendations by the Transport Department, the local council, the Environment Department, the Heritage Department, Treasury and Police. In Australia, because of the way our constitution is structured, it's not unusual to find projects where the money for the project is provided by the Commonwealth, but the actual work is done by the state. And then, of course, you add in the complexity of outsourcing, which we've just discussed. What this means is that there's always the potential for a person to apply for a review only to have the department assert that they're actually applying to the wrong department, because the decision which really ought to be reviewed was in fact a decision made by another department or agency. This could lead to a big round of finger pointing, which basically makes it impossible to work out who should be taking responsibility. To an extent, this has been overcome by the requirement for departments to indicate in their decision letters how the person can seek review of the decision. But it does make you think that perhaps there ought to be some sort of internal-external review, something that's halfway between the AAT and the Ombudsman, where a person can simply apply to the review agency and that agency can decide who's responsible. All of these questions, all of these controversies come right back to some of the material that we considered at the very start of the course. The fundamental idea is that if people are given power by the Parliament, if they're given power to make decisions that affect the lives of others, then they must follow the rules established for using that power, and there must be a process for normal people to challenge those decisions. I reckon many of you would have started this course with very little idea of what administrative law even was, and certainly with no idea of how important it can be. I started this course by making the bold claim that administrative law is basic human rights law. Now that you've learned the material, what do you think? Do you agree with me yet that administrative law is really the key weapon that ordinary people have to hold government decision makers to account, and to ensure that those decision makers use their powers lawfully and properly and rationally? If you plan to practice law, I can almost guarantee that you will run into administrative law really quickly. There are so many enactments providing so many powers to so many government decision makers that sooner or later your clients will need help. If you're not planning to practice, then whatever professional role you take, I can almost guarantee that your industry will be subject to substantial government regulation and your work will be affected by government decision makers. Having the ability to challenge those decisions when they do go wrong is crucial. But first, we have assessments. In the final video this week, which is the 39th and final video for this course, I'm going to introduce you to a comprehensive administrative law flowchart, which provides you with a central structure for all administrative law problems, whether they're in assignments or exams or real life. I hope you find that to be super useful. I wish you all the best for the rest of your studies and for your career in the law.